Deborah Schlossel on behalf of Mr. Laflore. Mr. Laflore, state your name. Mr. Laflore.
Is he still here?
Your Honor, he was on. I don't see him on the list. Can I waive his presence, Your Honor?
No, you can't waive his presence when we're addressing bond that I need to talk to him about.
I will text him, Your Honor, and let him know that we're waiting on him. I'm sorry, Your Honor. I did not know he was leaving.
I know. I understand. It's not your fault, Ms. Lussell.
Thank you.
Judge, is it okay if I get out and get back in?
Sure.
All right, I'll be right back. Thank you.
Well, we'll call the case of the Township of Ypsilanti versus Alante Stallings, case number 25T00361.
Paul Barnett on behalf of the Township.
Assistant Public Defender Davi Lieba on behalf of Mr. Stalling. Mr. Stalling, could you state your name, sir?
Alante Stallings.
Thank you. Good morning, Mr. Stallings. We're here for a pretrial today.
Good morning.
Yes, Your Honor, we'd like to set the matter for final settlement conference, please.
Final settlement conference will be on October 31st, 2025 at 9:30 a.m. with a jury selection of November 7th, 2025 at 8:30 a.m. Bond will be continued.
Thank you, Your Honor.
Good evening, sir. Thank you.
Thank you, Your Honor.
You're welcome. Have a good day, sir.
You too.
We'll call the case of Ypsilanti Township versus Daniel Ramirez, 24T00220.
Paul Barnett on behalf of the Township.
Assistant Public Defender Davi Lieba on behalf of Mr. Ramirez. Mr. Ramirez, could you please unmute and state your name, sir?
Hi, my name is Daniel Ramirez. I am present.
Mr. Ramirez, what's going on with your face?
I think you might have been brushing.
I'm sorry.
Spit that out and clean off your face.
I'm sorry, I'm getting ready to go to work in a little bit.
All right. We're here for a review today.
Yes, Your Honor, I did review the report from probation with Mr. Ramirez.
Thank you. Have counsel had an opportunity to review the email from his mother?
Your Honor, I did just receive that a moment ago and I have reviewed it.
All right. Mr. Barnett, have you reviewed it?
I'm sorry, Your Honor. Yes, I did. I just got it as well. I just got through it, so I have reviewed it as well.
All right, thank you. All right. And Mr. Lebo, with respect to the recommendation, do we have proof of the counseling status yet?
Yes, Your Honor, I did send that. I believe that has been sent to Ms. Johnson.
Mr. Lebo sent it, Your Honor, and Mr. Ramirez and his mother also brought it up last week to me.
Okay. So at this point, you're willing to recommend discharge with improvement?
Yes, Your Honor.
All right. Anything from you, Mr. Barnett, on that?
Given the circumstances, no objection to that.
Mr. Ramirez, thank you for doing what you're supposed to get done. And also, sir, I wish you and your mom nothing but the best. You are discharged with improvement at this time. Okay?
Thank you. Thank you, David. Appreciate it.
All right. Your case is now closed. Take care of yourself, sir.
All right, ma'am. All right, thank you. Thank you for all you public defender, and thank you, Agent Johnson, and thank you, Prosecutors, Auburn. You guys have a blessed day.
Thank you. He said thank you, Mr. Lebo, and to the prosecutor in case you guys couldn't make it out.
All right, bye, man.
Bye-bye. What will we call the case of the State of Michigan versus Melvin Laflore, case number 25S00335?
Give me what's for the people.
Deborah Schlossel on behalf of the defendant, Mr. Melvin Laflore, and Your Honor, please excuse the noise. I'm in 36th District Court.
All right, thank you. Mr. LaFloria, please state your name.
Melvin Lewis, LaFloria Jr.
All right, please turn on your camera, sir.
Oh,
All right, we are here we passed this so that you could reach out. Ms. Woods, what were you able to find out?
Our victim advocate had previously spoken to the mother of the child in this case, and we were under the impression that the child did not live there but was visiting there, and the mother of the child does not want her child to have contact with the defendant. So we are trying to reach out again to see if the child actually lives there, but we haven't heard back about that. But as of right now, the mother of the child does not want the child to have contact with the defendant.
Your Honor, given that, I would just ask that the no contact order be lifted and changed to no assault of contact, and my client will just not go to the residence.
No, it is always no assaultive contact. That's with anybody. And the order will be that there is no unwanted contact. So if she says that she does not want contact, then your client needs to leave. Mr. LaFloria, do you understand?
no, I missed. Oh, I thought it was regarding my wife. I know my grandson was the first part, but my wife, I missed that part.
With respect to your wife, sir, you can have contact. It's no unwanted contact. So if she wants to have contact, you have contact. If she says, I don't want you around, you have to leave. Do you understand?
Okay, I see. Yes, I understand.
Okay. There's still no contact with your grandson. So if he is present and at the home, then you may not go there. But
Understood.
if he's not there, you can.
I see. I understood.
So I'm going to lift the no go to, but I'm leaving the no contact in place. So if the grandson's there, he can't go there.
Judge,
you wanted to have a final settlement conference, is that correct?
Your Honor, yeah, we would like to set this matter for trial, Your Honor.
and the plea offer in this case is a DV4A with an alcohol assessment, and a referral to probation, but once it gets set for final settlement conference, that goes off the table.
And
We understand.
all right, you've had a chance to talk to your client about that.
Yes, Your Honor.
Okay. Final settlement conference, October 31st, 2025 at 9:30 a.m. with a jury selection of November 7th, 2025 at 8:30 a.m.
Thank you, Your Honor.
You're welcome. You're all set. Have a good day.
That hearing had a little bit of everything. Judge Irene Washington presided over a docket that moved from scheduling hiccups to heartfelt thanks and finally to some careful bond clarifications with Alante Stallings, who appeared with counsel for a pretrial. Both sides quickly agreed to set a final settlement conference for October 31st, with jury selection on November 7th, and Judge Washington continued his bond without fuss. The exchange was brief, professional, and free of drama, just clean scheduling. Next came Daniel Ramirez, whose review hearing turned out to be one of the brighter moments. Ramirez logged on a little flustered. His camera caught him mid-morning routine, but once settled, the court discussed his probation progress. His mother had sent in an email praising his improvement, and his lawyer confirmed proof of counseling had already been provided. The prosecutor raised no objection, and Judge Washington discharged Ramirez successfully, even wishing him and his mother nothing but the best. Ramirez responded with heartfelt thanks to the court, the prosecutor, and even the pastor who had supported him, the kind of gratitude you don't often hear in routine reviews. The final case involved Melvin Laflore, and here the tone grew more complicated. The prosecutor explained that the child's mother didn't want her son having contact with Laflore, though she believed the boy was only visiting the home. Defense counsel pushed to change the bond to allow no assaultive contact instead of no contact, but Judge Washington drew a firm line. Laflore could have contact with his wife only so long as it was wanted, but he was barred from any contact with his grandson, meaning if the boy was present in the home, Laflore could not be there. The judge clarified patiently when Laflore seemed confused. making sure he understood the difference between wanted and unwanted contact. After that, the case was set for trial, with a final settlement conference on October 31st and jury selection on November 7th. Across the docket, Judge Washington's demeanor was steady and thoughtful. She handled scheduling with efficiency, celebrated genuine progress when Ramirez showed it, and carefully explained boundaries in a more sensitive family case. The attorneys were prepared, defendants ranged from cooperative to confused, and the overall atmosphere blended efficiency, encouragement, and firmness. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.